If you're just tuning into this for the first time, you may be thinking, oh, come on, Larry. It can't be that bad. I don't believe you. I think it's not as bad as you think. So I challenge you. Well, hello everybody, and welcome back to a special episode of Buckle Up, It's the Law. Today we are going to be talking about the Karen Read case once again. A case that has captured the eyes and minds of millions and is the gift we don't want to keep on giving, but unfortunately, it's the gift that keeps on giving in all the wrong ways. It is like your ex-boyfriend or ex-girlfriend that just keeps gaslighting you into believing that it is your fault that they cheated in the relationship. It's that whole idea of, well, honey, you're only upset because I got caught, not because I did it scenario. It's the classic scenario. It's the repeated gaslighting, manipulating, deception, lies, and consistent misconstruing of facts in order to get their job across. And of course, I'm talking about the prosecution in the Karen Read case. Hank Brennan has been appointed as a special prosecutor in the Karen Read case. For those of you who are not familiar with the case of Commonwealth of Massachusetts versus Karen Read, let me fill you in on the details very quickly. A woman is accused to have hit her boyfriend with her SUV, thus killing him, leaving him in the snow to die in the cold. There was a trial last year in April 2024, which culminated in a mistrial at the end of June 2024, a trial that lasted about 10 weeks, 11 weeks, and has captivated the eyes and minds of people all over the world. It is a terrifying tale of corruption, misdeeds, and lies. And today I want to talk about the latest antics done by the judge in the case, as we call her Auntie Bev. Now, the reason we call her Auntie Bev is not to try and poke meaningless fun at a woman who is presiding over this case, who has clearly won the election and is sitting on the bench presiding over the Karen Read trial. People have nicknamed her Auntie Bev because of her consistent siding with the defense in the most absurd of ways. This is a case unlike anything anyone has ever witnessed. When the facts are just so obviously one-sided towards innocence, and yet there are two prosecutors working together to make sure that she does not get justice, and neither does the deceased, John O'Keefe, former officer John O'Keefe. And of course, when I'm talking about the two prosecutors, I'm talking about the newly appointed Hank Brennan and the judge, Beverly Cannoni, or as I said, we call her Auntie Bev. It has been one of the most frustrating cases to watch for a practicing attorney such as myself. No matter how much the defense is trying to fight against this judge and trying to simply introduce evidence of their own and to show that government evidence was not produced in a timely manner, which we will cover in this video, and was not produced in the way that it should have been, it makes a practicing attorney weep. Not just for the defense, but also for our justice system. Let's look at the latest filings in the Karen Read case. The defense filed a motion to dismiss on February 26, 2025. They filed a motion to dismiss all of her charges, citing extraordinary government misconduct. Which, by the way, for those of you who have not followed for a while, you may have missed the fact that one of the jurors came forward from the trial and has given not one, but two interviews now, one with NBC 10 Boston and one with Turtle Boy. So two interviews. Both times the jurors said, well, we voted not guilty on two of the three charges, but no one ever asked us what our votes were, and we didn't know that we can speak up. Because they're jurors. They don't know the rules. They're supposed to be guided by the court, and they were intentionally misguided by Auntie Bev. So what did the defense file? The defense filed a motion to dismiss, alleging several serious issues. Number one, altered video. Turns out that the video has been altered, which we knew for a very long time, but now we have exact timestamps in that motion. Alan Jackson claimed that surveillance video from the Canton Police Department Sallyport showed that Karen Reed's SUV was intentionally flipped and manipulated to mislead the jury during the first trial. The defense argued that this suppressed exculpatory evidence proves her innocence, because why would you edit and flip and invert a video if you know that you did nothing wrong? That's number one. Number two, the motion also asserts that prosecutors withheld video evidence that has later been produced to the defense. Number three, jury tampering allegations. This is a big one. Apparently, one of the officers who was involved in the investigation of the Karen Reed case, Massachusetts State Police Trooper Fanning, he was assigned to oversee the jury at the time of the trial. Do you see the conflict here? This is not a potential conflict. This is an actual open conflict. And yet, it doesn't seem to bother Bev in any way, shape, or form, the judge on this case. The connection to witnesses. They also highlighted, the defense in their motion to dismiss, highlighted a connection between Jennifer McCabe, if you remember, she was allegedly in the house when John's body was found outside, and Michael Lank. They had a direct relation. So that's just a brief summary of that motion. And the court heard arguments on this motion this past week. The district attorney's office, of course, responded saying there are no issues of ethical concern here, which is staggering to think about that that's going to be their response, but they have to respond in some capacity, I suppose. And in the same breath, they are asking the court to deny the motion to dismiss, that they have provided all the videos, that the remaining videos were not exculpatory, and that the judge should deny Karen Reed's motion to dismiss. In response to Allen's claim about the flipped video, the prosecutors have been arguing, and specifically Hank Brennan has been arguing, that the inversion was due to camera settings. We had nothing to do with it. They even cited two other videos from the same camera taken weeks earlier, which also happened to be inverted. Technical malfunction, you guys. Don't worry about it. It just happened, here, here, here. I believe there were either 7 or 8, possibly even 9 different instances in the motion cited by the defense stating where there were issues. And each one is just it's a technical error. Our bad. We're sorry. That is not how a trial is conducted. That is not how evidence is presented. And yet, if you watch the hearings, you will know that Judge Bev was simply irate more at Allen bringing these issues before her, rather than being angry at the prosecution for having those issues in the first place, which is the reverse. Again, it's the continuous cycle of gaslighting. It has become an extremely exhausting trial to watch for that reason. And the trial hasn't even started yet. This is motion practice. This is motion hour. Leading up to the trial, Karen Reed's attorneys have continued to press for access to withheld evidence, including the full surveillance video, which they still don't have to this very day. They do not have the full surveillance video from Canton PD as we sit here right now. Now, here comes the big one. The GAG order. This is quite extraordinary. Judge Bev issued a ruling Friday evening denying the Commonwealth's motion. There was another motion filed by the Commonwealth trying to impose sanctions on the defense for their leaking of information to the public and other things. So the Commonwealth filed a motion to prohibit the defense from making statements outside of court about the case, about evidence, literally asking the court to silence Alan Jackson and his team. This is also known as a GAG order. It is an extreme measure because we all have the First Amendment, number one. And number two, this is a very, very public, highly publicized trial. And so to ask the court to impose a sanction on the defense for their speaking about the case in the media and in public is already an unprecedented move, which should be outright denied, number one. And number two, not only were they asking for Alan Jackson and his team to be restricted in what they can talk about in this case, there was also a possible other extreme measure of removing the defense attorneys from the case entirely. Judge Bev did not go so to the extreme as to remove Alan, but here's what she said. She said, and she ruled this on Friday night, none of the lawyers appearing in this case, so she's lumping the prosecution in this, not just the defense, shall release or authorize the release of information that a reasonable person would expect to be disseminated by any means of public communication, basically don't talk about it, if the lawyer knows there is a likelihood or a substantial likelihood of prejudicing materially potential trial jurors or witnesses in this case. So what does that even mean? The language that she used, truthful information, honest facts about this case, could also fall under this umbrella. So if Alan Jackson does a TV interview and he talks about his ARCA witnesses or the failure of the government to turn over video evidence, which actually happened, he could be in violation of this order because it could materially prejudice potential jurors. She went on. None of the lawyers appearing in this case shall release or authorize the release of information that the lawyer knows or reasonably should know is likely to be inadmissible as evidence in trial and that would, if disclosed, create a substantial risk of prejudicing an impartial trial. Well, this one, okay, it kind of makes sense. Don't disseminate information that is not going to be admissible in trial. But how can the defense know if certain pieces of evidence are or are not going to be admissible? First of all, unless it's already been ruled upon, XYZ is inadmissible in trial, moving on to the next issue, counsel, fine. What about things that she's going to rule on later on? This creates a catch-22. Well, Your Honor, I didn't know at the time that the evidence was inadmissible. I know now. So are you going to punish me ex post facto, after the fact? So even though it has potential merit, it creates a closed loop that is inescapable and makes no sense. Number 3. This is the last one. None of the lawyers appearing in the case shall release or authorize the release of protected information in this case, including information subject to a protective order or information protected under the rules of criminal procedure. I mean, this one is obvious. If I'm putting this under seal, you have no right to release it. Okay, fantastic. That's an easy one. That one is fairly simple. If I'm issuing a protective order on this information, you cannot release it. Okay, fine. But what about the other two? To silence a lawyer and their method of dissemination of information in one of the most highly publicized trials, probably since the Johnny Depp trial. Like I said, this is the trial that keeps on giving, and we don't want it to anymore. We're tired. I haven't even been streaming this case. I know some streamers, shout out to you, Melanie Little and Peter Tragos, the lawyer you know. These guys have been on top of this case. I have seen them release videos almost on a daily basis covering this trial. I don't know how they're not exhausted. I've been covering this case for a couple of weeks since I got back into this, and I'm already tired. This is a mentally draining exercise because of the constant lies, manipulation, and gaslighting from the other side. There's just no winning. Basically, it's kind of like this. It's you showing your, significant other their phone with text messages saying, you cheated. I have the proof right here. You're talking to somebody else. That's not me. No, you're thinking of somebody else. But this is your phone. That's not my phone. What do you mean it's not your phone? This is your phone. Yeah, but those are not my texts. What do you mean these are not your texts? These are your texts. They're on your phone. That's somebody else. Well, they might be my texts, but the timestamps are all wrong. This was from years ago. This is not from years ago. It's like a constant barrage of no matter what you say, no matter how you try to argue, no matter how you try to convince the court, the judge, that it's a you problem. You did this. The court is simply unwilling, unable, does not care to listen to reason. Basic reasoning. And you guys, it is exhausting. I have never seen anything like this. You may be thinking, if you're just tuning into this for the first time, going, oh, come on, Larry. It can't be that bad, can it? I don't believe you. I think you are exaggerating, Mr. Forman. I think it's not as bad as you think. So I challenge you. Go back. Go on NBC 10 Boston's YouTube channel. Just scroll through. Find a point where Alan Jackson is speaking. Literally at any point, you will find countless interruptions, arrogance from the side of the court, the judge, continuous questioning of the defense and how they do things, relentless prodding into things that have no merit, that have nothing to do with the arguments, just to throw Alan Jackson and David Yannetti and Mr. Alessi off of their mojo, I guess. They even went so far as to try and get another attorney on this case because of their frustration with the court. A New York licensed attorney by the name of Mark Betterow. He was appearing on The Young Jerks for a while. He does not have his own YouTube channel, unfortunately. but he is on X quite a lot. And Judge Bev denied. She denied adding another lawyer to the team officially as a pro hac vici status, which simply means out-of-state attorney practicing in Massachusetts, arguing that there are already enough attorneys on this case. And not only that, she also highlighted a potential conflict with Turtle Boy, a journalist, because this lawyer has been communicating with a journalist, and this lawyer has indicated that he's going to create a Chinese wall between himself and this journalist. She said, no Chinese wall, no lawyer. I'm not getting into these games. Leave. Goodbye. So folks, trial is about 3 weeks away. We are still waiting on several decisions from Auntie Bev. Last year, I have lost respect for this woman because she has lost all credibility based on her rulings, her one-sided bias, and her relentless attacking of the defense. This year, I have lost all hope. The only way that this case is going to be won is with a jury verdict. And the court and the prosecution are doing everything in their power to try and convict this innocent woman. I am convinced, beyond convinced, if you look at all the evidence, if you look at all of the testimony, it is impossible, physically, scientifically, mathematically, rationally, impossible to conclude that Karen Reed killed John O'Keefe. And I hope, I pray that 2025 is the year that this woman finds justice, because this has to stop. She needs peace. And the corruption in Massachusetts needs to be exposed. The corruption in Canton PD, the corruption in Dedham and the Norfolk courthouse. I thank you all for watching, and I will see you all in the next video. Bye, everyone.